Good morning, everyone. My name is Allison DeGuide, and I'm with the Illinois Restaurant Association. I'd like to thank you for joining today's webinar on 10 key lease points every restaurateur needs to know. Today's webinar is being broadcast in English, Spanish, and Mandarin Chinese. To listen in Spanish or Chinese, please use the interpretation button in your toolbar. This webinar is being presented by the Illinois Restaurant Association in partnership with the Cook County Small Business Source. Established to ensure businesses emerge from COVID-19 intact and positioned for growth, the Small Business Source connects small business owners with expert guidance and support. Services include no-cost business advising, resources, and events that connect small business owners with a community of advisors. For one-on-one business advising, sign up at cookcountysmallbiz.org. It's free and easy to sign up. Also, before we begin, I'd like everyone attending to know that the Illinois Restaurant Association remains a source to you. We send regular email updates with what you need to know, and you can sign up for those on our website. For today's webinar, you can use the Q&A button to post your questions at any time during the presentation, and we'll do a Q&A session at the end. At this time, I'd like to introduce our panelists, Lawrence Swibel and Scott Schoenfeld, partners at Fox, Swibel, Levin, and Carroll. Take it away.
Good morning, everyone.
Good morning.
We're just sharing our screen here. We should be up. Yes. All right.
All right. I'm Lawrence Swibel, Scott Schoenfeld, my partner here, and we're going to talk about 10 key lease points that every restaurateur should know. Scott and I have been practicing in the hospitality area for many years. We have a specialty in restaurant practice. We handle restaurant leases, equity raises, management agreements, license agreements, and structuring deals for restaurateurs, restaurant groups, and chefs. So we're hoping that we can impart some interesting information for you. And we're going to start with point number one.
Well, in fact, an overview of the 10 key points. The first point is the use of a corporate entity. The second point is the rent commencement date. The third point is the percentage rent issues. Fourth is IP. Fifth is force majeure and pandemic relief. Sixth is tenant exclusives. 7, assignment and transfers of the lease. 8 are subordination and non-disturbance agreements, or SNDAs. 9 is market rent during extension periods. And 10 is TI allowances. And with that, Larry, take it away.
All right. Thanks, Scott. The first thing we want to talk about is what should be the tenant entity when you sign a restaurant lease. It might be apparent to you that you don't want to sign in your personal capacity because that would make you individually liable for all of the liabilities and obligations of the tenant under the lease. So the first thing you always want to do is use a separate entity, that is an entity separate from you as an individual, to be signing the lease so that the obligations and liabilities are confined to the tenant. That might be self-evident, but a bigger question arises is when you have more than one location. Do you want to use the same entity in multiple locations? And the answer is, in our experience, it is better, unless you are of a size where it becomes unwieldy. You want to have a separate entity for each of your locations, a separate operating entity. That way, your obligations under the lease to vendors, suppliers, employees are all confined to the entity that is operating that particular restaurant. So if one of your restaurants were to be having difficulties and you need to negotiate a lease amendment, for example, with a landlord, if you have a separate entity as the tenant under that lease, the landlord will have less leverage in dealing with you because the landlord's recourse, were you to have issues in paying your rent, would be limited to that particular tenant entity. So the key point we want to make here is that it would be beneficial to have a separate operating entity, usually a limited liability company, that you use for all of your respective leases. Now, that might raise the question. You might say, yes, but what if I do that and the landlord requires me to give a personal guarantee? That is true. You probably will have to give some sort of a guarantee. But there's a couple of things, a few points to note about that. Number one, even in that case, the guarantee will be limited to that particular lease. So you will only be liable for the obligations under that particular lease. Number two, you can try to negotiate a cap on the guarantee. The tenant will have unlimited liability. Your tenant entity will have unlimited liability, but you as a guarantor can try to negotiate a limitation on your liability under the lease. There's different ways we do this. Sometimes we have them reduce over time if there has been no default. Sometimes we simply have a cap from the beginning that remains in place throughout the lease. But the important point here is that having a personal guarantee gives you more flexibility in dealing with a limitation on your liability as compared to having you on the lease as the tenant yourself. So bottom line, best practice, create a new single purpose entity, probably an LLC, negotiate limitations on your guarantee, and you will have reduced your exposure as a restaurant tenant.
All right. The second issue is the rent commencement date. As you all know, a rent commencement date is the date on which rent under the lease commences. Often landlords in their leases provide that the rent commencement date is January 1st or April 1st or 180 days after you sign the lease. But that is tricky and problematic because sometimes, for example, the rent commencing is tied to the prior performance of the landlord's work. And what happens, and I'm sure that you guys can relate, what happens if the landlord has not completed its landlord's work, delivering the space in a certain condition with certain work performed by a certain date. And also, if the tenant's work is conditioned upon the prior performance of the landlord's work, it's also incredibly risky to have a hard date. A second issue that is similar is permits. As you all know, the city of Chicago requires having a building permit or a C of O. And if you practically haven't obtained that permit in a reasonable period of time, or if the city is delayed or is simply hard to work with, you are now risking paying rent prior to receiving a building permit, which is a terrible outcome. And then finally, for example, as you guys know, during COVID, the pandemic created all kinds of obstacles related to supply chain issues. So if you were ordering a special type of wood for your bar from China or from wherever, and it simply could not get there, now you're paying rent potentially, and you haven't even gotten the necessary supplies to actually open and operate. So in this instance, the absolute best practice around a rent commencement date is make sure that you have a rent commencement date, which is a set period of time following the satisfaction of each of the following: the landlord's work and the receipt of permits. And as always, you should expressly subject the rent commencement date to force majeure events, and force majeure events should extend rent commencement day for day.
So bottom line, as Scott was saying, you want that rent commencement date to be keyed off something where the risk of delay is shifted to the landlord from the tenant. Delays beyond your control. Of course, if there's a tenant delay, that is the tenant's responsibility. But these are things, permit delays, landlord delays in its work, things that are beyond your control should not be your risk. And you want to shift the risk to the landlord and tie rent commencement to the fulfillment of those things that are beyond your control.
That's right. All right.
Okay. Our next point, and there are a number of issues to discuss on percentage rent. It is common, of course, in restaurant leases for the tenant to not only pay a base rent, but also pay a percentage rent if sales are in excess of a certain threshold, which is referred to as a break point. And the three key points we want to focus on when negotiating percentage rent are, number one, the definition of gross sales. Let's talk about that for a little bit. you're going to be paying percentage rent frequently on a percentage of your gross sales, and gross sales are typically defined as everything that you derive in the way of revenue from the operation of the restaurant. It could include the sale of merchandise, if you're selling T-shirts or cups or mugs or other kinds of paraphernalia.
Gift cards.
There are some things to keep in mind. You want to make sure that you exclude from the definition of gross sales
Anything that you don't make money on.
Right. So, for example, we like to reduce from our gross sales credit card fees. You are paying, these are charges you are paying to credit card companies, typically in the area of 2.5% or 3%. That is very negotiable with landlords. Many landlords will resist that. A lot of these things they might say are the cost of doing business. They're not things that should be reducing gross sales, but we always try to get that carve out. Number two, gift card sales. If you're selling gift cards, as you know, you don't take those into income until the gift card has been redeemed, not when you receive the money for the gift card. So you want to make sure that you are not paying a percentage of those gift card sales to the landlord unless and until those gift cards are redeemed. There are other things that are fairly standard in the industry. If you are making charitable donations that are legitimate charitable donations, you might want to see if you can get those reduced from your gross sales. Obviously, gratuities, you're collecting money, but you are remitting that to your employees. That is not money going to the restaurant. You don't want to pay a percentage of those to your landlord in gross sales. But now there are a few things that have become a little bit more negotiable and perhaps even controversial in recent times. Delivery fees, as you all know, many of you are paying substantial fees to delivery services such as DoorDash and Grubhub and Postmark and the like. We always try to get delivery fees, or at least some percentage of delivery fees, reduced from the calculation of gross sales. That is money that is going right out the door from your standpoint, and it is reducing the revenue you are receiving from the sales. And so it is always a good idea to see if you can get those excluded from the definition of gross sales. There are a few others here that we've included, including sales taxes. That's usually non-controversial. You are collecting that money, you're remitting it to the governmental authority for tax purposes. Those should be reduced and excluded from gross sales. There are a number of things these are simply examples, frankly. We could not cover all of them in a single session like this, but the important thing to remember is that when you're looking at the definition of gross sales and what you are paying a percentage of to the landlord, there are a host of things where you are collecting money, but you do not want those to be included in gross sales and because they're not really revenue to the restaurant. The next point on percentage rent, and this is a nuance that many people are not very mindful of, but can make a big difference, is when do you pay percentage rent? What is the schedule of percentage rent? From a landlord standpoint, it is not unusual for the landlord to say, okay, if the threshold, the break point that we're talking about, let's say it's $3 million in sales, above which you are going to pay a percentage. A landlord would like to say, we're going to look at that every month, and we're going to take 1/12 of $3 million, and to the extent your sales in that month exceed that 1/12 amount, then you are going to pay percentage rent above that, and then do that on a monthly basis. Sometimes you'll see it on a quarterly basis. The one thing we want to make everybody aware of is you should never agree to pay percentage rent on anything other than an annual basis, because that will indicate whether or not your sales for an entire year have been sufficient to generate a percentage rent obligation. If you do it on a month by month or quarter by quarter basis, you might have a period of time that is an outlier, where for that shortened period of time, you exceeded the shortened prorated portion of that break point for the year, the threshold for the year, and you end up paying percentage rent in a year where perhaps the total annual sales do not exceed the annual amount of the break point for the year. So you never want to be agreed to pay percentage rent on anything other than an annual basis. The third point we want to mention about percentage rent is understanding how the break point is calculated and knowing that you can negotiate various aspects to it. The most common way that this is approached is that the tenant pays a percentage, and it's a negotiable percentage. 5% is a fairly standard amount above what is called a natural break point. And the natural break point is where the gross sales equal the annual minimum base rent divided by the agreed upon percentage. So in our example, if your annual rent is $200,000 and you are paying 7% above a natural break point, that calculates the break point to be $2,857,000 roughly. So points to be aware of here. The percentage is negotiable. 5% is pretty standard. You can try to go for 4%. Landlords sometimes will ask for 6%, or as in our example, 7%. As you know, you never want your occupancy costs to exceed 10%, and better yet, 8% as a cap of what you want your occupancy costs to be relative to your sales. So you want that percentage to be as low as possible. The break point itself is also negotiable. It does not have to be a natural break point. You can calculate what's called an artificial break point. So in our example, it doesn't have to be $2.8 million as the break point. You can say, I'll pay 7% above an artificial break point. We're going to make the artificial break point $3.5 million. Obviously, it's a negotiable point. Doesn't mean the landlord will agree to it, but always know that you can negotiate the percentage. You can negotiate the calculation of the break point, and you can have a sliding break point so that if your sales are slightly above the break point, you might pay a smaller percentage. But if you really hit a home run, you're willing to share a little bit more of that with the landlord. And so the percentage can increase. You can have different thresholds, different break points at different levels, and have different percentages associated with each of those disparate break points. So it's not just one size fits all, and know that these are the kinds of things you can negotiate and try to negotiate your advantage in any lease.
All right. The fourth point, and it's crucial, is about IP. I think a commonly overlooked issue with restaurants is that the single most valuable asset a restaurant possesses is its IP. And that includes both the company's trademark as well as the restaurant concept. A restaurant concept is the look, the feel, the menu design, the service style, and the cuisine. It's sort of a soft aggregation. And that's what...
And the name.
As well as the name. And that is what distinguishes one restaurant from another. So if the IP is the company's single most valuable asset, who owns it and who should own it? Unsavvy restaurant owners sometimes, in fact, often provide in their operating agreements that all intellectual property of the company is owned by that company. The problem with that is if you have more than one store that's operating under your concept, then who owns the IP? If they're all saying in their operating agreements that that company owns the IP, do they all own the IP? Do absolutely zero of those companies own the IP? And if you have investors in a particular restaurant, what ownership do they have? And also, if you sell a restaurant, have you sold the IP? So these issues present the hazards associated with IP. How do you solve for this? The solution is to use an IP holdco. So here's a chart, and I want to make sure that you guys understand exactly what's happening here. Here we have two different stores, Restaurant Store LLC 1, Restaurant Store LLC 2. We have a holdco entity, which is the 100% owner of both stores. In this instance, Larry and I are 50% co-owners of that restaurant holdco. We also are 50% co-owners of the IP holdco. In order to avoid the perils that I just described associated with IP, we have created the IP holdco to own all of the IP, the trademark, the restaurant concept, all of it related to the concept. And for each of those stores, we have provided for an IP license. And so in this instance, if someone wants to buy the entire concept, what they would also buy is the IP holdco. And this is crucial because if you have different investors in different entities, you need to segregate out the ownership by making sure that you have the holdco owning the IP separate from the investor entities owning the IP.
Now, a couple things to keep in mind is that if you are starting with your first restaurant, you might have to induce investors, if you are bringing in investors, to give them a share of the intellectual property on the theory that they're with you at the beginning, they're helping you build the brand, they're with you at the start. That's something to consider where you give them some percentage ownership. We still recommend that you keep the intellectual property separate, but you can have an investor entity also have a small percentage of the intellectual property entity. And I know this sounds like we're getting into a lot of lawyerly stuff, but these are important concepts in the restaurant world to make sure that you have thought about who's going to own the intellectual property. Another thing to think about is, and we've seen this done in a number of deals, if a concept is sold and all of the restaurants under that concept are sold as part of a package, it frequently, the purchase price frequently does not specifically separate between the intellectual property and the price that's being paid for, if you will, the revenue stream or the income stream from the restaurants. So we have sometimes advised clients, it depends on the circumstances, to agree in advance if you're bringing in partners or investors who you do not want to have an ownership of the intellectual property, where you might say, in the event of a sale of all of our locations, and if the sale price does not separately allocate a portion of the price to the intellectual property, again, that being the concept, the goodwill, the brand, the name, the trademark, that we will in advance agree that any portion of the purchase price in excess of an agreed upon multiple of earnings. So you might say anything that's paid for the basket of restaurants that we're selling that's in excess of a 5 multiple of earnings will be deemed to be attributable to the intellectual property, or 6 multiple, or whatever multiple of earnings you agree in advance would be a standard in the industry of what people pay for income streams in the restaurant business. Anything above that you agree in advance is attributable to the intellectual property and therefore is paid to the owners of the intellectual property, not to the owners of the restaurants themselves.
That's right. That's right. All right. The 5th point is force majeure and pandemic relief.
Obviously, this is an evolving area. COVID brought in all sorts of issues that we previously had not really thought about in the negotiation of leases. It's funny how we in the world frequently react to recent events. So after 9/11, we saw a lot of provisions now relating to closures due to terrorist events. Now we are dealing with closures due to pandemic health events, which are now much more foreseeable perhaps than they once were. This is a somewhat, I mentioned the evolving area and somewhat heavily negotiated area. And it might depend to some extent if you are dealing with a landlord who treated you well and was reasonable during COVID and gave you some concessions. Obviously, if you're dealing with a new deal with that landlord or an amendment to your lease, it becomes a little bit less of a concern, and you might not want to spend a lot of time negotiating these points if you think, well, if in the unlikely event this occurs again, we'll be able to work something out. But in most cases, you will not be in that situation when you're signing a restaurant lease. And it is now very common in the industry to deal with what happens if there is a health pandemic or something of the sort that causes a closure of your restaurant. And as we saw during COVID, there's sometimes where partial closures where you could operate at 50%, let's say, capacity. And so now we come up with all sorts of variations on the theme. Note that, as posted here on our slide, a common force majeure provision, if it does not specifically address pandemics, typically will have a provision that says that the inability to operate or simply pay rent is not in and of itself a force majeure event. And so we need to address what happens in the event of a pandemic. Now, many of you might have gotten, if you were operating during COVID, might have gotten deferrals as opposed to abatements of rent, and then found that the deferral was just kicking the can down the road in that not paying rent during a period of time, but then having it accrue and having to pay it at a later time when you reopen was not much of a real panacea for you. And so the things we want to talk about now are the distinction between deferred rent and an abatement. If you can get an abatement, obviously that is the best solution for you. A deferral is better than nothing, but if you get a deferral, what you want is to be able to pay that off over as long a period of time as you can, because you will reopen. There will be a ramp-up period when you reopen. Having to start paying all that deferred rent in a short period of time becomes very difficult. So you want to hit this on the head in your negotiations. You want to have different options to think about. We've talked about abatement or deferment. Another one would be a termination option. Now that may or may not be a particularly good remedy for you, and is one that the landlord will likely resist. But we have been able in certain circumstances to negotiate into leases that if you are precluded from operating to a certain percent, it may be 75% or 100%, for a period of time, it may be 6 months, it could be 9 months. The standards are always negotiable, but getting a termination option, while you might think to yourselves, boy, that's kind of not really great for me because I've got this investment in the build out, I've got reputation, I've got goodwill, but keep in mind that the termination option doesn't have to be exercised. It may give you significant leverage in dealing with a landlord in trying to get the concessions that you really want, which would be the abatement or the deferral. So it's a tool that can be used even if a termination option is not really what you hope to have to exercise.
And if you have a guarantee in place, a personal guarantee, and you're facing exposure for all of the rent coming due, a termination option is a tremendously powerful tool because you are going to be able to otherwise cap the amount of liability that the guarantor would otherwise have. So that's option 2. Option 3, Larry, is?
Yeah, option 3 is a good one, and it's one we are able to get for our clients with some regularity, and that is just a conversion during the pandemic period from the scheduled minimum rent to a percentage rent, where you're only paying a specific percentage of your sales. Presumably, if the right percentage is negotiated, you will be paying less in rent during the pandemic period. You are not saying to the landlord you won't pay anything if you're able to conduct business, but on a reduced basis. It's asking the landlord to share in the reduction, but you're not asking the landlord to bear the entire cost of the impairment of your business. And that is one that landlords are more open to, because in the end, they don't want you going out of business. They want you to stay. They want you to stay in business. They want you in the long term. And so converting to a percentage rent only basis during a pandemic is an option that we've seen landlords be pretty open to, and we're able to get for our clients.
And I have also found that you are able to persuade a landlord to accept option 3 if you tell them that option 3 only kicks in after 30 or so days have passed in which the tenant cannot operate in the ordinary course, a true wipeout event. And if you have a true wipeout event, then landlords understand that if you are operating, then it's fair to simply provide for percentage rent to the extent that you are able to operate and not otherwise have minimum rent kick in. The other point being, of course, that if you have a true wipeout event, the landlord has to play ball, because otherwise, if they kick you out, they aren't going to be able to find some substitute tenant to come in and operate during that period. So option 3 is truly the best of all 3 options. And it's the option that Larry and I push for strongly in most of our leases. All right, with that, talking now about tenant exclusives. So a tenant exclusive is most relevant if you are a restaurant operating in a shopping center or a large strip center. In that permutation, if you're a chicken concept, for example, and you specialize in chicken fingers and chicken sandwiches, and in your lease, the landlord tells you that you have an exclusive to operate a store whose primary business is the sale of chicken-related food and menu options. And candidly, that language is pretty common. It's vague. So I asked in the PowerPoint, what does that language mean? Does that mean that you have an exclusive on the sale of chicken? Does that mean that you exclusively are able to offer a menu comprised primarily of chicken products? Answer, at best it's vague, and without spelling out exactly what your exclusive protects, you basically have only bought yourself a future dispute. So how do we solve for this issue in practice? Solution number 1 is to operationalize your exclusive by the percentage of menu options. In that instance, I would perhaps consider language saying that landlord acknowledges and agrees that no other tenant at the shopping center can have a menu of which more than half is comprised of chicken-related options. Of course, that solution number 1 is tricky, because if you have a store which is down the street and they have one menu option driving 40% of their sales, then solution number 1 hasn't really protected you.
And I would also point out that you want the menu items to be measured based on food, not beverage as well. So, because you can get tripped up if you simply say menu items and there's a large offering of beverages, then what is essentially a chicken competitor next door becomes less so, because its percentage of sales derived from chicken is much smaller if you're including beverage sales.
That's right. All right. And then solution number 2, which I think is definitely superior, is to operationalize the exclusive by percentage of gross sales. So the alternative language is providing landlord acknowledges and agrees that no other tenant at the shopping center may generate more than half of its gross revenue from the sale of chicken-related menu offerings. Now, the problem with that, of course, is it presupposes that the landlord has the right to get gross sales receipts from other tenants. If they don't, then landlords are going to push back on solution number 2, leaving solution number 1 as perhaps your only option. But solution number 1 is definitely better than having vague at best language protecting your exclusive.
But before we leave this topic, there are some other considerations that we wanted to mention. Your exclusive right does not necessarily have to be tied to a specific menu item. It certainly could be based more on the theme of your restaurant. If you have a Mexican restaurant, you might want to exclude other restaurants whose primary theme is Mexican offerings. So it can be based on theme. It could be based on specific menu items. I had one client that was a national restaurant chain, a Mexican concept by coincidence, and they had their own signature guacamole. And they also had maybe 50 different kinds of margaritas. Those were the 2 big selling points. So their big thing was they wanted to exclude any other competition in the center. they wanted to exclude anybody else selling guacamole or margaritas. They didn't care if it was a Mexican restaurant, although most Mexican restaurants would be selling those items. But they wanted to make sure they had an exclusive on those two particular offerings. You also could focus on an exclusive that is based on the price point of the restaurant. You might want to be the only fine dining in a particular shopping center, where the competition that you want to keep out is not based on what they are serving, but the clientele to whom they are serving. And so if you want to be the only fine dining restaurant, you might say that there'd be no other white tablecloth full service restaurants whose price points are comparable to ours. So there's lots of different ways of approaching exclusives, theme, specific menu items, price points. But do think about, if you're going into a multi-tenant building, do think about some things you might want to do to try to protect yourself on this.
All right. 7, assignment and transfers of the lease. Such an important area.
Yeah. Okay. So, of course, when you go into a lease situation, you don't necessarily expect to be looking to get out of it, but things change, circumstances change, and there is always a negotiation around how flexible the tenant how flexible the tenant's rights are regarding the right to assign. The first point we want to make, and this should be an absolute and should not be a problem from a landlord standpoint, is there are certain internal, what we would think of as internal transfers. You might want to shift ownership of your entity from one affiliate to another. You might have other control parties coming in, things that really don't impact the landlord, but give you the flexibility to reorganize your own organization, if you will. There should be a list of permitted transferees where, even if the landlord's consent is otherwise required for a transfer of the lease, you have the right to make certain transfers, again, between affiliates, if you're combining two of your entities into one, things like that, entities under common control with the tenant, those should be permitted transferees right off the bat.
But the single most important issue to confront in connection with transfers of the lease is what happens if you have a lease and you are selling not simply that store, but you are selling the entire concept. If you are subject to a landlord consent on that lease, you face a scenario in which you would have to go to your landlord for your store, for one store, and you are otherwise holding up your 7-store chicken sandwich sale to the whims of one landlord,
who will, of course, exercise that leverage and say, oh boy, if you need my approval to sign this lease in order for you to consummate a sale of your company in all of your locations, I want a pretty penny for my approval.
That's right.
So we always try to negotiate in advance for any tenant that either has or expects to have multiple locations, a provision that allows the transfer of the lease without the landlord's consent if it's part of a bigger transaction. One common thing we try to do is if it's 3 stores or more operating under the same concept. You might have 10 stores, but you're going to sell 3 of them to somebody. Again, any transaction that involves more than one location, 3 would be kind of a low amount for us to get. That's where we start. Sometimes it's 5, sometimes it's 7, sometimes it's substantially all or substantially all the locations. But the point to be made is if you have multiple locations, you want the ability to transfer any one lease as part of a transfer of multiple locations without a landlord holding things up.
Of course, the landlord pushback, and Larry and I see it all the time, is you have the prior language saying that you can transfer in connection with the transfer of 3 or more stores, but then the landlord says, so long as such third-party purchaser is a first-class quality operator of similar restaurants and also has a net worth no less than tenants as of the moment immediately prior to such transfer.
Right. And so when you see that language, any language which is going to in any way qualify your right to transfer, you want the language to be as objective and not subjective as possible. So first-class quality operator, a term like that might give a landlord the opportunity to say, I don't think that the people you're selling to operate at the same level you do. So try to avoid those kinds of subjective tests. You might say that you might want to substitute that the purchaser has been operating in the business for at least X number of years. That's an objective test. That doesn't necessarily guarantee it's a first-class operator, but it gives the landlord some comfort that the purchaser knows what it's doing and is not a novice in the industry and has just decided to get into the restaurant business by buying these stores, and that this is its first foray into the restaurant business. But an objective test is much better for you than a subjective test. And on the net worth, no less than tenants at the moment immediately prior to such transfer, that one usually can be met, because if the buyer is buying multiple stores and the only test is it has to have a net worth greater than the tenant in that particular store, that one typically is one we don't worry about too much. But there are other net worth tests that sometimes a landlord tries to impose, and just be mindful that if, to the extent there are any tests or qualifiers as to what your purchaser must meet or satisfy, you want to keep those as easy to satisfy as possible.
All right. Number 8, subordination and non-disturbance. So often the leases are going to provide that tenants are subject and subordinate to any prior existing senior lien securing the building. And that's fine. But the problem is, if the lease is executed subsequent to the owner's senior lien, then in the event that your landlord, as the borrower under that loan, defaults, as a matter of law, if your lender forecloses on the property, they can, as a matter of law, wipe out your lease. And so you have a situation in which, as a tenant, you've poured all this money and time into this enterprise, and through absolutely no fault of your own, through the exclusive fault of your landlord, you are facing the risk of being wiped out.
Now, I just want to interject here, because I've had many clients say to me, why is that really a risk? If a lender forecloses, won't the lender bend over backwards to try to keep me as a tenant as opposed to get rid of me and terminate my lease? Here's the answer. There's two circumstances, at least, that I have seen where a lender wants to terminate a lease after foreclosing on the landlord. Number one is where there is a prospective buyer for the property and they want to do a complete redevelopment and bring in their own tenants. Obviously, your landlord would not have had the right to terminate your lease to do it, but the lender, having foreclosed and you have subordinated your interest to the lien of the lender, gives the lender the right to bring in a new buyer, a new landlord, who has the right to then terminate, or the lender can terminate your lease so they can bring in a new buyer. The other is, I've seen a lender decide that a lease is below market, and even if they don't want to terminate, they go back to the tenant and say, we want to renegotiate your lease. We think that this lease you signed 3 years ago or whatever is now a below market lease. We want you to renegotiate, and if you don't renegotiate, we will terminate you. So it is a real risk. It doesn't happen a lot. I don't want to overstate the risk. Most lenders do want to keep tenants in place, but it is a real world risk that there are circumstances under which a lender will use that right to either terminate or renegotiate.
And so, during the lease negotiation, you're often going to see language saying something to the effect of that, notwithstanding all of the foregoing, the landlord agrees to use commercially reasonable efforts to obtain an SNDA from its lender. And that's better than nothing, but it's not good enough, because commercially reasonable efforts often won't be enough. And the lender simply says, no, I won't give an SNDA recognizing this tenant. And so, depending upon how much investment there is, how large the space is, it can be really, really crucial to negotiate a hard right to obtain an SNDA. And I think one vehicle to get there with a difficult lender and a difficult landlord is to simply say that you agree to accept an SNDA on the lender's standard form. And the lender's standard form is extremely lender friendly, but notwithstanding, it protects you against the parade of horribles that Larry just described earlier.
Yeah, and I would go so far as to say that this is an issue, while many of you might kind of be rolling your eyes because it's a very legal, nuanced issue. We actually advise our clients to negotiate this into your LOI. If you're negotiating an LOI, a letter of intent, or a term sheet, if you wait till the lease negotiation, you'll be pretty far down the road, and a landlord almost certainly will say, well, we're not going to guarantee you an SNDA. We'll use our best efforts, and then you may or may not get it. If you negotiate it into the LOI, then it becomes a point of you are going to be entitled to it in the lease negotiation, and the landlord, I suppose they can back off of that position, but they are much less likely to try to resort to their, we'll try, but we can't guarantee anything. Okay, next point, market rent during extension periods. This is one that a lot of restaurateurs don't think about too much. You may negotiate you'll have a term for your lease. Maybe it's a 10-year lease, and maybe you have a 5-year extension option or 2 5-year extension options. And very frequently, those extension options will say at the then market rent. And you think to yourself, well, that's fair. I should, as long as I have the right to stay in there and pay fair market rent, I'm fine with that. The nuance here is, how is fair market rent determined? What is your right if you disagree with the landlord? And how do you make sure that you really have the right to a fair market rent? Because many landlords will initially take the position that the landlord will give you a notice a certain number of days in advance of your extension option of what the landlord's determination of fair market rent is. And many leases will say you have a certain number of days to accept or reject that. And your option is, if you reject it, to withdraw your exercise of the extension option. That obviously doesn't give you very much protection if the landlord's determination, even if arguably reasonable, is at the very high end of a range, or it could be unreasonable because the landlord doesn't want you to stay. If you're bound by the landlord's determination of fair market rent, with your only alternative being to terminate the lease or withdraw your exercise of your option if you disagree with it, then you don't really have much protection. So if you are going to agree to a fair market rent, and we'll talk about whether or not there are alternatives to that, but if you do agree to a fair market rent during your extension option, you want to have some mechanism for disputing the landlord's determination of fair market rent, where it goes through some kind of dispute resolution mechanism and is determined by a third party if you and the landlord cannot come to an agreement as to what fair market rent is. So one of the options we use is, and it's a common option, is if we disagree, we as the tenant can propose what we think is fair market rent. If the two parties don't agree, you go to a baseball arbitration, what's referred to as baseball arbitration. And the reason it's baseball arbitration is, in arbitrating baseball players' contracts, each side proposes something and the arbitrator has to choose one or the other, cannot split the difference. It keeps the two parties a little bit more honest and reasonable because neither one wants to be so far off the range that the other party's valuation will be accepted. So a very common way we like to approach this is landlord proposes something, tenant proposes something. If they cannot agree during a 30-day negotiation period, it goes to a third-party arbitrator who has to choose one or the other. And then at least you have some protection that the landlord is likely to be a lot more reasonable in its initial so-called determination of fair market rent.
However, an option here is to avoid accepting fair market value and consider, during the letter of intent, negotiating a specified rent during the extension period. For example, just continuing to use 2.5% annual escalations of minimum rent. Larry?
Well, keep in mind, if you are able to do that and you negotiate for the just the continued escalations, let's say you've had 2.5% per year and you say those will continue during the option period or periods, you might be thinking to yourself, but boy, what if that escalated rent is higher than the fair market rent? Keep in mind, this is an option on your part. You are not obligated. So at that time, you go back to the landlord and say, we'd like to stay in the space, but we're not going to exercise our option at 2.5%, another 2.5% escalation. Let's negotiate what we think the fair market rent is. So it gives you the advantage of locking in an amount that may be favorable. And if it is not favorable, you don't exercise your option and you try to negotiate what the fair market rent will be.
Yeah, and the final point is to make sure that you negotiate that any extension option is not simply personal to the named tenant, but also extends to any permitted transferees, particularly given the example that Larry just mentioned, which is if you have been so successful to negotiate a below market option, that can be a very valuable tool in your toolbox. The final point, and I'm going to try to be quick to keep time for questions, is TI allowances. With TI allowances, there are 4 main issues to address when negotiating them in a lease. The first one is, how is the TI allowance dispersed? Is it dispersed in one fell swoop once the restaurant has opened? Is it dispersed in tranches? And if so, is that on a monthly basis or as a percentage of the overall completion of tenant's work? And if it's determined based upon completion, who determines that? Is it landlord? Is it tenant? Is it landlord's architect? Is it mutually agreed upon? And if so, what happens if you disagree? Also, can you apply both soft and hard costs towards the TI? Soft costs being, for example, architect's costs and engineering costs and legal costs and zoning. And if you are able to apply soft costs, are those soft costs capped at a certain percentage of the overall TI allowance, 10%, 20%? Second, with regard to your TI, after a certain period of time following lease execution, does the TI go away if you haven't used it all? And if so, how long? Is it 12 months following execution, 2 years, 6 months? You have to be very careful to not lose your right to get your TI. And then finally, what is required to get it? Landlords should only condition disbursement upon partial and then final as applicable lien waivers relating to the work for which you are submitting invoices to get your TI. And for that, the absolute worst case scenario that you can face is if you are submitting invoices and the landlord is requiring all invoices, all lien waivers, but you aren't able to pull a small lien waiver from a subcontractor for $500 or $1,000, and the landlord is conditioning the disbursement of the allowance based upon the receipt of all waivers. So make sure that you consider carving out small amounts of money as irrelevant for purposes of getting your TI dispersed.
Yeah, and one other point I want to add that wasn't on our slide is a remedy that you want to reserve for yourself if the landlord does not honor its obligation to pay the tenant improvement allowance. Most leases will have a general provision that says that if you have a claim against the landlord, you cannot offset it against rent or withhold rent. You have to separately pursue the landlord. This is one where we would say if the landlord hasn't paid the tenant improvement allowance, you should try to reserve the right of offset against rent,
right,
so that you don't have to separately sue the landlord for that money, but you have the right to offset it against your rent payments.
That is a great point. And now we are going to take some questions from the audience.
Perfect. I'll go ahead and start asking them if you don't mind. That was a great presentation. So first question is, how much notice is my landlord legally required to give me before I have to move out once my lease is up?
Well, before the lease expires, generally the lease will have, if the lease has an expiration date, the landlord's not required to give you notice at all. I mean, you know, when you sign the lease, when your lease expires. If the question is, if the landlord is claiming you are in default and the landlord is going to pursue action against you, then again, you have to look at your lease to see what the notice and cure rights are. Generally, leases will have provisions that will prescribe the amount of notice a landlord has to give you to cure any default that you've got before the landlord can take any action against you. But going back, if the question literally is how much notice do you need of the expiration of your lease, unless the landlord has unless the lease has an unusual provision that requires such a notice, it's the tenant's responsibility to know when the lease is going to expire.
Okay, the next question, is there any way to terminate a lease agreement early?
It truly depends upon the express language in the lease. If you do not have an expressly defined termination option in your commercial lease, then as a matter of law, you do not have a termination option for your lease.
Right, but that's the legal answer. The practical answer is if you have set it up the way we suggested early on in point number 1, that you have a single purpose entity as your tenant, and maybe with a guarantee that you have to worry about. But I did have a situation recently where the landlord had not gotten a guarantee and had accepted a single purpose entity as the tenant. We did not have the legal right to terminate, but we did terminate the lease early. We left, and the landlord was really left without any recourse because its tenant was a restaurant entity that had gone under and had no assets. It was insolvent, and there was no other entity the landlord could look to as a guarantor. So there may be practical things you can do to reduce your liability, but it doesn't mean you have the legal right to walk. It does mean you might have some practical ways of reducing your liability for doing so.
Perfect. Someone said, thank you for the intel, and it was excellent. And they asked, how much money and time should an operator allocate for attorney representation for a restaurant lease?
You want to know our fees? Boy, does that vary. And I will try to give you something more meaningful than just a bunch of words, but I have to start with the words, and that is that there is no one size that fits all. You know, we've had deals where it's a 1,500 square foot lease and there's no percentage rent to discuss, and it's a gross lease where you're not negotiating with the pass-throughs and protection on tax increases. That kind of a lease probably is under $5,000, I would say, for our fee. Others may be more expensive, others may be less expensive. I don't know. We have, on the other hand, had 20,000 square foot leases with very complicated provisions and lots of negotiation. And those deals can take $20,000 or $25,000. So I know that's a very broad range, but you know, it's harder to be more specific because deals vary so much based on the size, based on what the lease provisions are. Some tenants are particularly focused on getting exclusive rights. Some landlords want to prevent tenants from opening up competing restaurants in a nearby location, and they argue for radius restrictions. There's just lots of things that go into these. The smaller the deal, obviously, the less complicated it is and the lower the fee. But again, at the lowest end for us, it's hard for us to do anything really meaningful for a client for less than $5,000.
That's right.
No, I think that's really helpful, and I imagine it's money well spent. Do we have time for one more question?
Sure.
You know what? Okay. Is it common or uncommon to negotiate property taxes on an NNN lease? How can an operator protect themselves from soaring property taxes?
Yeah, it's a question we get a lot from tenants. The NNN being a triple net lease where there are pass-throughs to the tenant of its proportionate share of taxes. There aren't any really brilliant ideas. We have in the past been able to negotiate caps where we say that the tax increase, irrespective of what the actual taxes increase, will not exceed a certain percentage in any given year. We have seen it where you go in with a base year at least, so that you're not paying your proportionate share of the absolute tax bill, but you use a base year as your initial lease year, and then you're paying increases only and above the tax level when you start your lease. That's one way to reduce your real estate tax obligation. But it's hard. It's easier to get a cap on pass-throughs of common area maintenance costs because a landlord
Has
will-
control
has a
over
little
those.
more control over those. Landlord will say, look, I can't control taxes.
Right.
You could argue or try to negotiate in the lease an obligation on the part of the landlord to challenge real estate taxes on an annual basis to try to keep the taxes down. But the cap on percentage increases would be the most, I think, practical way of trying to get to that.
Okay, great. So I think that'll be our last question. We're at the end of our time. I would like to thank you all for attending and thank Larry Swibel and Scott Schoenfeld with Fox, Swibel, Levin, and Carroll. I'd also like to thank the Cook County Small Business Source for their continued support. Following the conclusion of this webinar, attendees will receive an email with links to the webinar recording and presentation. Thank you all for attending and have a great day.
Thank you.
Thank you.
Thank you.